we will be recording for everyone. Okay, so we are going to start if Angus is ready. Just to say thank you very much for joining us this morning, everyone. I think this is a very interesting topic, so I'm also eager to hear what Angus has got to say. As you know, for those of you who attend regularly, Angus likes an interactive audience, so please feel free to pop any questions or comments in the chat box, or you're welcome to raise your hand, and Angus will get to you perhaps after his presentation, which is not going to be very long today. So let me hand over to Angus and we can get started.
All right, good morning, everyone. Welcome to our session this morning. Quite an interesting topic, which 2 years ago to the day, well, not quite to the day, to the month anyway, I presented a similar brunch with Bailie on this topic where the High Court had made the ruling, which the Constitutional Court has now verified. So just a little bit about myself. I'm sitting here next to Tracy, and if I don't tout myself enough, she's going to kick me under the table. I am a practicing attorney, have been for a few years. I like to round down to 20. It just makes me feel a little bit younger. I've been an acting judge in the Labour Court. I've lectured at university. I'm a CETA accredited trainer facilitator, and I put together a number of courses for companies, both in-house, these webinar presentations, etc. And I thought, let's we do these brunch with Baileys from time to time, free little webinars where we discuss little interesting cases that come along from time to time. I'm going to share my screen. So as Tracy says, I do like a discussion platform. So if you do have any comments, questions, queries, you're more than welcome to put them in the chat section, and we can then go from there. So brunch with Bailie, that's me. And today we're going to be talking about parental leave, the basic conditions of employment and the Constitution. Oh, can I just ask everyone just to mute themselves or make sure that you're muted? It can be a little distracting for everyone if you're not muted. So, like I said, October 2023, the High Court issued a ruling, court order, Van Wyk and others. And in terms of which they basically said the sections of the Basic Conditions of Employment Act were unconstitutional. It put an interim ruling in place, and it gave government 2 years to sort out the section. That 2 years came and rolled around, and nothing had happened. Surprisingly, I know everyone is very shocked about that. But in the interim, what happens is whenever the High Court makes a constitutional court decision or a decision based on the Constitution, it goes to the High Court for ratification or adoption. And in this case, and just to give you an idea, if you ever wondered how long it takes to get a constitutional court decision, here's a very clear indication of 2 years. So it went from the High Court to the Constitutional Court, and 2 years later, we now have the Constitutional Court judgment. So take a step back. So the Johannesburg High Court declaring Section 25 unconstitutional gave Parliament 2 years to cure the defects with it. So basically, in a nutshell, 2 years later, we now have the Constitutional Court ruling, which confirms the High Court ruling. So the Constitutional Court confirmed the ruling. So not much changes as far as that's concerned. However, it said the 2 year period is now giving Parliament another 36 months to fix the sections. So in other words, well, good grief, giving Parliament another 36 months to fix the sections of the Basic Conditions of Employment Act, and with it the UIF Act, because obviously they go hand in hand when we're talking about parental and maternity leave. So what happened? Let me just give you a brief background as to what happened here. So Mr. Van Wyk was gainfully employed. His wife had her own business, and she gave birth, and he wanted to take the baby with the maternity leave and spend time with the baby so his wife could immediately get back to work. It made more financial sense for them to do that. And he approached the High Court saying that it's unfair constitutionally unfair that females should get 4 months and men should only get 10 days, sorry. Um, you know, discrimination based on age, not age, sorry, gender. And that's basically where it revolved. And at the same time, there were a number of other cases dealing with adoptive parents and surrogacy parents who were also petitioning the court for parental leave on the basis of adopting a child or getting a child during surrogacy. So the High Court considered all of those concepts and came up with the ruling, which now the High Court has adopted. So what does that mean for everyone? So the notion of maternity leave as we know it and parental leave, paternal leave, so the 10 days for men and the 4 months for women is scrapped. It's no more. What happens now, though, with those 4 months and those 10 days? In other words, and very simply put, what basically has happened is the court has said the 4 months and the 10 days can now be split equally between the parties, jointly and severally. So they both have a claim to the 4 months and 10 days. How the 4 months and 10 days will then be decided by the parties. Okay, so there's still leave, but instead of calling it paternity leave or maternity leave, it's now called parental leave. So if you're the biological parent or the adoptive parent or the surrogacy parent, you are entitled to this 4 months and 10 days. It's still unpaid. So for the employers having minor heart attacks about that, that hasn't changed. You can still claim UIF, and that's why portions of the UIF Act also have to be amended, because under the UIF Act, it's the mother who would have claimed the 4 months and the father would claim the 10 days. Now that has to be changed so that whoever is on leave can claim the UIF. All right, so what does the Constitutional Court say? So firstly, parental leave applies to parents jointly and severally. So in other words, it's a combined thing. You have 4 months and 10 days, and how you split it up is then between you as the parents of that child, or the adoptive parents, or the surrogacy parents. So hopefully you can understand that you are entitled to it collectively, so the 4 months and 10 days, and they shared amongst themselves. So mom and dad will basically decide how much they're going to take. So dad takes 2 months, mom takes 2 months. That's one option. Mom takes 3 months, dad takes 1 month. What I think from a practical point of view, and for my clients that have been on this webinar, when the High Court made the ruling in 2023, I put this clause in your contracts already. So we've been operating under this system for a while. And basically, it's a situation, and I found from a practical point of view that what happens is the parents decide whose salary is higher, and whoever's earning the most tends to go back to work quicker or spends less time on leave because it's unpaid. So you want that salary back. And the one who earns less tends to spend then more time on the maternity leave or paternity leave, as it may be. Okay. So I think that's fairly straightforward. The leave is shared equally unless agreed. And when I say agreed, it's agreed between the parents. The employers don't have a say in the matter. So the parents will decide amongst themselves how it needs to be provisioned. What is important to understand, now this applies to the ladies that give birth, and that includes the surrogacy mother that would give birth. She's also entitled to the leave. So for the person giving birth, they must be off 4 weeks before the birth and 6 weeks after. That does not change. So in those instances, the mother would have to take the 4 weeks before and the 6 weeks after the birth. The balance of the leave would then be agreed between the parties. What I see from a practical point of view is I find that a lot of people, especially where the leave is unpaid, the mother will take the 4 weeks before, so that would be your first month, done. Then the mother takes the 6 weeks after, and thereafter returns to work if her salary is higher than the father's, and the father takes then the balance. Obviously, I'm not going to get into the social dynamics and cultural dynamics around leave and who should be looking after the child, etc., etc. But that's just from a practical point of view. I find that money tends to rule, and whoever's got the highest salary generally tends to take take the least amount of leave possible, and whoever earns the least tends to take more leave because it just makes more financial sense for them to do so. But it agreed between the parents. And it's a case of informing the employer how that leave is going to be taken. All right, so hopefully that makes sense. The age cap for adoptive parents was removed. So initially, under the High Court ruling, it was only newborn, adopted where you adopted a newborn, that you would be entitled then to this parental leave. The Constitutional Court has removed that. So now any adoption, regardless of age, will entitle parents to the 4 months and 10 days. Okay. Interesting, that I find. Same applies to surrogacy, although surrogacy generally implies a newborn. But like I said, so the surrogacy mother who gives birth will be entitled to the 4 weeks before, 6 weeks after, and the balance would then be split amongst the parents who are then taking the child thereafter. Okay, so hopefully that makes sense. I don't think that's too contentious. So that's basically the provisions. The big question I'm normally faced with is what now? What do employers do? So first and foremost, I just need to mention that it is unpaid. That does not change, as I've said. Those of you who have paid maternity leave in your policies are going to have to redefine your policies. So first and foremost, if it hasn't occurred to you already, is you need to review and amend your leave provisions in your contracts of employment, as well as your leave policies. Now, as far as that's concerned, first and foremost, if it's in a contract of employment, and a lot of employers have it in their contracts of employment because the Department of Labor and the Basic Conditions of Employment requires that it needs to be one of the written particulars furnished to an employee. So generally found in your employment contracts. It's a contract of employment, which means amending it requires the signature of the employee. You cannot unilaterally change the contract of employment, which I envisage is going to create some very interesting conversations, although in reality, I don't see any employees having an issue with this amendment. It's to their benefit. So I don't anticipate them saying, no, sorry, please, I don't. But if it's in your contract of employment, you are going to have to amend your contract of employment. That's just the nature of it. If it's in your leave policy by and large is normally something that the company can just unilaterally amend or change and then notify the employees of the change. So first and foremost, reviewing and amending your policies, and then obviously creating awareness. I'm sure most of you know that wherever you change a policy, you do need to inform the employees of the change in policy, etc. Those of you with collective agreements with unions, where leave policies are part of that collective agreement, would then also have to require the consent of the union to change the collective agreement. I don't anticipate that being too much of an issue. Again, it's in their favor. So there you go. Does this mean you can, if you have paid leave, that you can then change it to unpaid leave? Yes. It's a discussion point. The rules have changed, the law has changed. So does it entitle me to do it unpaid? Yes, you can revert to that. But again, if it's a contractual term, you'd have to negotiate that with the employee. If the employee refuses, it has to remain paid. Okay. What I am offering to the delegates that are on this course, those of you that require the wording for the policy, we are offering the wording of the policy. It's a short template, and I'm offering it to everyone who's attending this course for R1,000. So if you're interested, you can contact Tracy and we can do that. If you are looking for a sort of more comprehensive discussion around the point, obviously I'm available for that as well. You can either contact me directly or Tracy, and we can go from there. All right. So that's the first thing. The second thing that needs to change is your leave forms. Now, how this is supposed to work from a practical point of view is that, as I'm sure you know, like with any leave, the employee has to apply for it. It is a statutory leave, and remember the mandatory minimums of 4 weeks and 6 weeks after have to be abided by. But as for the rest of it, the employee puts in a leave form, and this is quite important, particularly because the leave is going to be shared between parties. So as part of your leave form, you need to now make provision in your leave form for this to say, right, I am taking maternal or parental leave and I am taking so many days, my spouse or my partner or the biological parent or the adoptive parent or the surrogacy parent or whatever the case may be is taking so many days. So that's going to have to be specified in the leave form so that there's no confusion around it. You get the employee to tell you what leave they're taking and what leave the other party is taking. All right. Part of that also there needs to be a discussion with the other party or the other party's employer, assuming they're not both employed with you. So if both parties are employed with you, it's a relatively simple discussion. You can then monitor and match it yourself. However, if the other party is employed by somebody else, you are going to have to discuss that with the other party or the other party's employer. So that's going to need to be disclosed. You're going to have to approach the other employer and say, my employee is taking so many days according to the leave form they've completed, so that there's no overlap. And as you may know, employees might, I mean, I know this might be shocking. Employees might actually try and take advantage of this, where both parties are trying to claim the full leave. So that's why it's important that employers communicate with each other. So that's payment for UIF and parental leave also needs to be clarified. So those of you who do paid maternity leave, whether in part or in full, also another reason why your leave form needs to be clear as to who's taking what, etc. And then obviously the claiming from UIF doesn't change. It's just the party that's claiming from UIF will change according to the percentage that they are taking. So another reason why leave forms are important. And then, as I said, contacting and liaising the other infected employer is quite important. What I would like to just stress before I close this point is POPI. And that's why I put in brackets there. It's important that we consider POPI because we are dealing with personal information and we are dealing with medical information. Now, under POPI, medical information is considered special information, which cannot then be distributed or processed, as the Act terms it, without the consent of the parties. So again, come back to your leave form. Built into your leave form should be a little paragraph or a sentence to say that the employee consents to you processing the information by contacting the other employer, etc., etc. Okay. So I think overall, it's created a whole lot of extra admin for the HR people, and I can see they're very excited by these provisions. Employers, on the other hand, it is a little bit of a headache, but I think overall, I think it's a good judgment. I think long time coming. Certainly around the discussion around adoptive parents and surrogacy parents, they've been on this bandwagon for quite a while, around being able to access maternity or paternity leave. So I think overall it'll be interesting to see how Parliament eventually rewords the sections of the Basic Conditions of Employment Act, but I envisage that the rewording is not going to be too different from what the Constitutional Court and the High Court have said it should be. Because if the Constitutional Court has said this is what it should be, it's very difficult for them to sort of argue around that. It's the highest court in the land. It's the decision has basically been made. So I think it's really just a case now of wording that's going to be important. But yeah, I think we're stuck with this. Like I said, those of you that are my clients, I've already put this clause in your contracts. So it's just a matter of policies and that kind of thing, leave forms that need to be drafted. And as I said, again, those of you that are interested in the wording, I've got a small policy document that I can share with you guys. And I said we'd be doing that for R1,000. So you can contact Tracy. She will then get a list and off we go to the races as far as that's concerned. Okay, so that is basically the presentation in a nutshell. We do tend to keep it short and sharp and to the point. Those are my contact details for those of you that don't have them. You will also be given a copy of the presentation as well as the Constitutional Court judgment. Tracy will send it to you guys so you have it. Those are my contact details if you need to get hold of me. So I'm going to stop the share and we're going to come back now to the main screen. And we can see, I see there are a couple of notes in the chat section here. So Robin has asked, is it working, the 10 working days? Yes, Robin, it's the 10 days. So whenever the Act refers to days, they refer to calendar days or consecutive days. So it's not working days, it's calendar days. Whenever the Basic Conditions of Employment Act refers to days. Okay, so it's 4 months. Those 4 months are not working months. I mean, that would be something completely different. So it's 4 months and 10 days, which is then calendar days. Okay, calendar months as well. So Warren has asked, as per 4 months and 10 days collectively, would HR departments need to discuss with spouses? Yes, they would. Like I said, Warren, absolutely. You don't need to worry. It's already in your contracts. You may have noticed. So it's already there. The only clarification there might be because of Poppy, you guys are going to need to get consent of the employees to discuss with the other employer. You could make the argument that it is a legal requirement and therefore Poppy allows you or exempts you from getting consent, but I would rather just build that clause into the leave form and then there can't be an argument around it. Okay. Algius asked, how would the respective employees know and verify how the leave has been split, i.e. if the dad decides to take the full and requests the leave and the mother does the same, are they both No. So remember, you have 4 months and 10 days. That's the total amount. So it's like a pizza. The parents then need to decide how that pizza is going to be broken up. Bearing in mind, remember what I said, the 4 weeks before the birth and 6 weeks after the birth, the biological mother who's given birth must take those days. Those are non-negotiables. So in terms of the pizza, it's almost like saying the mom will take 10 slices of the pizza and whatever's left can then be agreed as to how it's going to be split between the parties. But you only have the one pizza. You can't take more than what's already there. So there's going to be a discussion between the parents. The only thing is they need to inform the employers, their respective employers, as to how that pizza is going to be split. Okay. All right. Brandon asks, how does HR verify it's been split? What prevents? So I think it's a similar question there, Brandon. Yeah, you're going to have to discuss this with the other employer. Again, get consent, and it's going to require HRs talking to each other on this point. If you do find, and this is the interesting part, this is where I'm smiling now because this is where lawyers make money, is that where employees now do take advantage, I know it's unthinkable. They would never do such a thing. But if you do find an employee has lied or manipulated the system, that would be abusive leave. It's a misconduct, and it can be dealt with through your disciplinary process. Okay. Makota asks, because men can have more than one child in a year, how does the new parental leave law handle that? Can the working father take 4 months and 10 days leave for each birth if both mothers don't work? The short answer is yes. Yeah. So yeah, is the short answer is yes. In theory, I mean, if I have 2 wives, or a wife and 2 mistresses, or whatever the case may be, and heaven forbid they all get pregnant at the same time, or in consecutive sessions, or whatever it is, yes, in theory, I would be entitled to parental leave for each of those. Yeah, bearing in mind again, the biological mother would have the 4 weeks and 6, so she would have the 10 weeks for the actual birthing period, and I could then take the rest of that pie in each case. If they overlap, then I don't gain any benefit. I can't get more leave than what's already there, if you understand what I'm trying to say. So it is going to lead to some very interesting discussions. Yeah, it's one of those unintended consequences, I think, of this particular act. Bearing in mind, again, it's unpaid. And the reality is, with our sort of climate, particularly the financial climate, is that I don't see parents trying to abuse this too much if it's unpaid. If you've got a paid parental leave issue, then this is going to be a problem for you. Um, yeah, so it's an interesting question, but in theory, yes. If I'm the father and I have three women pregnant, I have three opportunities to take leave. Um, why I would do that to myself, I don't know, but it's there. All right. Brendan's asked, what is the age limit on adoption? There used to be an age limit as to newborns. There's no longer an age limit. In terms of legality, I mean, I can adopt anyone up to the age of 18. Family law is not really my practice, but if I'm correct in my understanding of the Children's Act, it applies to children, and therefore children are anyone under the age of 18. So I can adopt a 17-year-old and get this leave. I can't adopt a 21-year-old, not in terms of the Children's Act anyway. So there you go. I think so. The short answer there would be I can adopt anyone up to the age of 18. As far as I understand it. So take that with maybe a pinch of salt. I don't do family law. That's my partner's purview, but that's my understanding of the Children's Act. Okay, so Laura's asking, am I correct in understanding that if you were paying 45% of the salary, you now need to pay 40%, 45% to the mom and the dad, or make it unpaid in the policy, i.e., you can't only pay mom 45%? That would be discrimination. No, Laura, not quite. So you are paying your employee. So I think that it's an interesting question. Let me phrase it like this then. So you have a contractual obligation or agreement with that employee to pay 45% of their salary during parental leave. That's a contractual obligation with that parent. If both parents work for you, then you've got that obligation with both parents. But if only one of the parents work for you, you pay that parent. So if that parent takes 2 months, you pay them for the 2 months, and then they return to work, and then they're back to their normal salary. I don't now have to go and pay the father who doesn't work for me 45% of his salary. No, you don't have an agreement with that parent. So it's not a requirement for you. Okay. What he has with his employer, so if his employer is unpaid, that's unpaid. That's not your obligation. Your obligation is to your employee. The problem comes in is if they're both your employees, then if mom takes 2 months, you pay her 45% of her salary while she's on leave. And if dad then takes 2 months, you pay 45% of his salary while he's on leave. Or however they've decided to break that down. Hopefully that makes sense. But the short answer there would be there's no obligation on you to pay an employee who's not yours their salary. If they don't work for you, that's not a contractual obligation. What I've said to a lot of my to my clients on this particular point is that this is a great opportunity for you to sit down and revisit whether you want to have paternity paid leave or not, because now you could argue you have an operational requirement to revisit this issue. And look at possibly amending it and changing it, etc. Obviously, we require negotiations with the parents or the employees, sorry, around whether it should be reduced or scrapped altogether and revert back to the unpaid situation. So that's going to be a very interesting discussion if you want to go that far. Right. Oh, sorry, the discussion has jumped along there. So Sandra's asking, if a mother, our employee, would like to take parental leave in full, should we still contact the father's employer? Yes, absolutely. If your employee comes to you and says to you, listen, I'm taking the full leave, I'm the biological mother, I'm taking the full leave, they put in the leave form, I would strongly argue that you then communicate with the father's employer to say, our employee is taking the full 4 months and 10 days, which would then effectively mean that the father would get nothing. Because that is what would have been agreed between the parties. Okay, so yeah, 100%. You would still communicate with it. Otherwise, what's happening is the father's telling his employer he's taking the full 4 months, and that obviously would be abuse of the system. Elga's asking, what is the time frame for companies to comply with this, to implement through across the company as per government stipulation? So the Constitutional Court ruling is a ratification of the High Court ruling. The High Court ruling was in 2023. So already in 2023, this should have been implemented. But a lot of employers didn't know about it, don't know about it. But yeah, effectively, immediately would be the answer to that question, Elga. It's with immediate effect. Parliament has 36 months to reword the section, but what the High Court and the Constitutional Court have done is they've said in the interim, while Parliament is sorting itself out, these are the rules that need to apply. And the High Court did that in 2023 already. So it's been in effect for 2 years already. And it's going these interim provisions that the Constitutional Court has set are going to be in place for another 36 months, so another 3 years, before Parliament gets its act together. And if you think about it, that essentially has given Parliament 5 years to sort this out, which to my mind just blows my mind. But there you go. Okay. So Laura's asking, can we still insist on a month's notice of the leave to be taken from the dad? I'm assuming you want him to come to you in advance, a month in advance, and ask for the leave. Remember, when an employee becomes pregnant, they need to notify their employer as soon as reasonably practicable. So this is something that shouldn't be a surprise. Like, oh, look, hang on, my wife is pregnant and I'm taking leave. So again, part of your leave policy, yes, you could make that a requirement of your leave policy. I don't think it's unreasonable to expect parties to let you know in advance that this is what they're doing. So yes, you could require that of a father in particular or both parties. I don't know what your leave policy says around the mother notifying you when she is pregnant. A lot of employers have stipulations around that, particularly because they have to take a month before. So a lot of employers sort of require sort of at 32 weeks at least. By 32 weeks, you must notify your employer that you're pregnant, etc. That can be part of your leave policy. And it's simply just a matter then of saying that both parties need to notify you at the very least 8 weeks before the birth or a month before the birth, or whatever the case may be, 2 months before the birth, whatever. Yeah, so that would be a matter for your policy to decide. I want to say Liesel. Apologies if I've massacred your name. Can we refuse a male employee to take 4 months and 10 days given we expect the mother to take 10 weeks each time? Can we insist a male only takes the 4 months and 10 days minus the 10 weeks? Yes, you can. It's a requirement. So look, obviously the biological father can't take the full 4 months and 10 days. Because of that 10-week period that the biological mother has to take by law. So yes, you could basically say, look, it's impossible for you to take the 4 months and 10 days. The mother has to take at least 10 weeks. You can have the balance, but yeah. So in short, yes. Because somebody has to, unless of course it's an adoptive parent. And now there's the interesting part, because an adoptive parent, let's say I'm adopting a 5-year-old. There's no birthing period. And I'm the father adopting the child. I want to take the 4 months and 10 days. Then I'm entitled to the 4 months and 10 days because I'm adopting the child. There's no birthing period requirement there. So hopefully that makes sense. Francis has asked, if the adoption took place a year ago and the parents now want to take the leave because they did not have the opportunity, that there's a hard no on that, Francis. I would say to the parents, sorry, that ship has sailed. It should be from the point of adoption, because the idea is once I adopt the child and the child is now mine, the idea behind it is that I then have 4 months and 10 days to now build this bond with the child, same way a new mother would or a new father would, etc. So no, a year down the line, 2 months down the line, no, that ship has sailed. It needs to be immediate, and it needs to, and like I think it was Lisa who said, is that something they need to apply for in advance. Sorry, Laura. They need to apply for in advance, I think. It's not a leave that can just be dumped on you. Again, something that you can put in your leave policy to say, look, if you want to access this leave, it has to be applied for in advance by so many weeks, so many days, etc., etc. You can't just spring it on us. Okay. And I don't think that's unreasonable because obviously as employers, you need to make provisions, make plans, etc. Melody and Heather, oh no, sorry, Sandra, has asked if both parents are employees, could they in theory apply to take the leave simultaneously? No, it has to be one following the other. So it would be one following the other. They can't both take the 2 months at the same time. Um, so no, it has to be 4 months and 10 days consecutively, following on from one another. So no. Again, something that you can address in your policy if you really want to. So that's an interesting point there, Sandra, but the short answer to that is no. Melody and Heather, if the employee refuses to give the info of the other spouse's employee under POPI, what are the legal implications? That's a very interesting question. So like I said, because this is a legal or a lawful provision, you could use that exception in POPI to say, this is by law, I have to do this. Therefore, I don't need your consent. Um, and you can at the very least advise the other employer of what's gone on, if you know who the other employer is. The problem sometimes from a practical point of view is I don't know who the father is. I don't know them. I don't have their contact details. I don't know if they're working. I don't know if they're not working. And that's going to be a very interesting practical discussion. Um, because if the employer refuses to give you that information, it's not something you can waterboard them to get. Or some other form of interrogation. You can't discipline them into giving it to you. Um, so yeah, that will create an interesting scenario. Um, yeah. So the short answer there is, in theory, if you know who the employer is, at the very least, you can advise them that, listen, my employee is taking so many days. You don't need to disclose anything more than that. You can simply just disclose that they are taking so many days. What that employer does with that information is not up to you. Okay. Whether they accept the information, refute the information, reply with what their employee is taking, that's obviously then a different story. Okay. Sorry, I know it's clear as mud, but as a lawyer, we're smiling because these are the kind of things that we're going to make money off of, because I can just see the confusions and the disciplinary hearings that are going to come out of this. So yeah, what if employees, Liesel is asking, what if employees refuse to tell us where their partners work or even who their partner is? Um, We've had an employee refuse this information mainly due to the fact that it turned out the father was married to another. Oh, heavens. This is like a well-written soapy. The father was married to another of our employees, but we're often not told who the partner is, and we surely cannot force this information. So the short answer there, Liesel, as I've just replied, is that, look, reality is you can't force that information from somebody. We're going to have to be clever about how we do it. Look, I mean, yeah, it's if they refuse to give the information, we could make the argument that they shouldn't be entitled to the full ball of leave or whatever the case may be, but it is going to be difficult. Um, and that is an interesting scenario that I think that's something that would have to be dealt with on a case-to-case basis. But in those instances, there's not a whole lot you can do. You're just going to have to get the employee to sign the form, acknowledge that that's the leave they've taken or they want to take, from your point of view. And if they're saying they're taking the 4 months and 10 days, well, then that's what it is. If you somehow, through some investigation, find out that that wasn't the case and that their partner had also taken leave, well, then you can open the door to disciplinary action after that. But how you would then, from a practical point of view, find that out, I don't know. Certainly not without violating the POPI Act or not overtly violating the POPI Act. So yeah, it is going to present some very interesting scenarios. What I would say there, Leslie, is that what I would do is when I am taking the contact details of an employee when they commence their employment, um, I would be very careful to make sure that I have their spouse's details, partner's details, whatever it might be, maybe adding that onto your contact detail list form, before this becomes an issue. Now, that's obviously working on the assumption that the partner is the one that's the father of the child or the mother of the child. But in this case, that would be a very interesting conversation. But yeah, that's really the only way you can do it. If they refuse to give it, they refuse to give it. You can't compel them. I certainly don't see a situation where you can compel them to give you that information. Robin, thanks. Tracy shared the information. So Maria's asking, thank you, very informative. Pleasure. Marlinda, can both parents take leave at the same time? I think I've answered that. So I've said no. It has to be consecutive. So one parent takes a certain stretch, then the other parent may take. So, but they can't take it together. Just for clarity, 4 weeks before the birth is included or not? It is included. So that 4 months and 10 days includes the 4 weeks before and the 10 weeks after. Sorry, 6 weeks after. So those 10 weeks for the birthing parent are included in the 4 months. Okay. Elga said it's very informative. So pleasure. Thank you. And Jane, if the mom does not work, can the dad take all the leave? In theory, yes. Unless the mother's giving birth, of course. If the mother's giving birth, she has to have those 10 weeks. So the dad can't take all of those. I know she's not working, but she's still, in theory, the birthing parent, so she would be taking the 10 weeks, I would argue. Okay. So the father would have the balance of whatever the birthing mother does not take. Melinda's asking, can't both parents be present? I'm sure they can be, Melinda. I think that's a matter of policy. If parents want to be there on the day of the birth, I'm pretty sure you can allow that. At the very least, as maybe a family responsibility leave day, I say that sort of tongue in cheek. But yes, look, I think it's meant to run consecutively, but if you want to allow them both to be present, absolutely, I don't see that being a problem. How you then want to calculate that in is up to you. Okay, so everybody just saying thanks. I know I'm awesome. He says with great humility. So yes, no, thank you very much. I really do. It's my pleasure. I'm glad you guys have found this to be very informative. For those of you that don't have questions, or I know I've chucked a lot of information, or you don't want to ask specifically now, I am available. You can pop me an email, or send Tracy an email. She's very good at getting me to respond to things. If you are interested in a discussion around policies and that kind of thing and wording, by all means, I am available for that. So yes, that's that. I don't see any other questions.
Okay, well, if that is it, thank you so much for joining us today, everyone, and we hope to see you soon again. Have a great day. Bye.